Not being satisfied with the same, the respondent filed an appeal before the appellate authority. Stop. The appellate authority dismissed the appeal by an order dated 10/4/2008, concurring with the order of the Chief Public Information Officer of the appellant. Stop. The first respondent thereafter filed a second appeal before the Central Information Commission (for short CIC) in regard to queries 1 to 5 and 7 to 13. Stop. CIC, by an order dated 23/12/2008, rejected the appeal in regard to queries 3, 5 and 13 while directing the disclosure of information in regard to the other questions. Stop para. Feeling aggrieved by the rejection of information sought under items 3, 5 and 13, the first respondent approached the Bombay High Court by filing a writ petition. Stop. The High Court allowed the said petition by the order dated 30/11/2010 and directed the appellant to supply the information in regard to queries 3, 5 and 13 on the following reasoning. Stop para change. According to the Central Information Commission, the solutions which have been supplied by the board to the examiners are given in confidence and therefore they are entitled to protection under Section 8 Subclause 1 Subclause E of the RTI Act. Stop. Section 8 Subclause 1 Subclause E does not protect confidential information and the claim of intellectual property has not been made by respondent to anywhere. Stop. In the reply, it is suggested that the suggested answers are published and sold in open market by the board. Stop. Therefore, there can be no confidentiality about suggested answers. Stop. It is nowhere explained what is the difference between the suggested answers and the solutions. Stop para change. In our opinion, the orders of both authorities in this respect also suffer from non-application of mind and therefore they are liable to be set aside. Stop. We find that the right given under the Right to Information Act has been dealt with the authorities under that Act in most casual manner without properly applying their minds to the material on record. Stop. In our opinion, therefore, information sought against queries 3, 5 and 13 could not have been denied by the authorities to the petitioner. Stop para. The principal defense of respondent 2 is that the information is confidential. Stop. Till the result of the examination is declared, the information sought by the petitioner has to be treated as confidential, but once the result is declared, in our opinion, that information cannot be treated as confidential. Stop. We were not shown anything which would even indicate that it is necessary to keep the information in relation to the examination which is over and the result is also declared as confidential. Stop para change. The appellant claims to follow the following elaborate system with established procedures in connection with its examinations, taking utmost care with regard to valuation of answer sheets and preparation of results and also in carrying out verification in case a student applies for the same in accordance with the following regulations. Stop para change. Chartered accountants with a standing of minimum of 5-7 years in the profession or teachers with a minimum experience of 5-7 years in university education system are impaneled as examiners of the institute. Stop. The eligibility criteria to be impaneled as examiner for the examinations held in November 2010 was that a chartered accountant with a minimum of 3 years standing if in practice or with a minimum of 10 years standing if in service and university lectures with. Stop.